Good afternoon, everyone. Thank you for joining us for this final webinar as part of MOVA's Victim Rights Month webinar series. My name is Lisa McHugh, and I'm the Director of External Engagement here at MOVA. Today's webinar will feature Patty McNamara, Director of Victim Compensation, and Nikita Bethel-Smith, Victim Compensation Eligibility and Outreach Specialist, who are here to provide exciting updates on the victim compensation regulations. Before we get started, just a few things. This is a webinar format, so attendees are not visible to the presenter or audience, and the audio is not enabled. We're providing ASL interpretation and captioning for today's session. To view captions for this presentation, click on Show Captions at the bottom of your Zoom screen. And if you would like to view CART interpretation in a separate window, please click the CART stream link provided in the chat. Today we'll be using the Q&A function, not the chat, for questions at the end of the presentation. To submit questions for the presenters, you can use that Q&A function, and we'll be viewing that at the end of the presentation for a question and answer section. So today we just wanted to announce in 2025 to enhance and streamline victim compensation, access and service delivery. The Victim Compensation Program was transferred from the Attorney General's Office to the Massachusetts Office for Victim Assistance. It's my pleasure to introduce Patty McNamara and Nikita Bethel-Smith, who will walk us through key updates in emergency regulations filed as a result of this process. Patty, I'll turn it over to you.
Thank you, Lisa, and thank you all for joining this webinar today. I had a chance to look at the list of folks who registered and saw many names I'm familiar with, and I'm very happy to see you all here. And anyone who I haven't met yet, I'm really looking forward to connecting with you as we move forward in this important work. We're very excited to talk with you directly about MOVA's work in transitioning victim compensation. Victim compensation began at MOVA just about 1 year ago. We focused first on creating a team to implement MOVA's mission of providing services that are survivor-informed and empowering. We began with a new team of claims advocates and a new eligibility specialist whom you're meeting today and whom we encourage you to connect with for further training for your programs. We're very pleased that within our team, we have language capacity in Portuguese, Mandarin, Cantonese, and Spanish. So the team is focused on continuity of services and engagement with survivors and victims. As part of the legal process for the transition, MOVA was required to immediately file emergency regulations to replace the prior regulations that applied to the Attorney General's office. The major requirement of the emergency regulations was to establish MOVA as the named agency. We were operating under a very tight time window to submit these regulations. However, we were able to take the opportunity to insert some changes to the regulations that immediately expanded access for victims and survivors. This presentation is about those changes. The MOVA team has been operating under these changes, and claimants have already begun to benefit from them. We're excited to share information with you today about the changes and look forward to our ongoing collaboration in support of victims and survivors. As community partners, we appreciate you sharing this information. And as we have been responding to victims and survivors, we've been identifying eligibility for benefits under these changes. And Nikita has included information about these changes in her presentations to providers as part of the outreach that we've engaged in through MOVA. So now I'm going to turn things over to Nikita to begin our presentation. Thank you.
Thank you so much, Patty McNamara, to MOVA. We are so excited to be here this afternoon. A big thank you to everyone who does victim services across the state of Massachusetts and all the capacities and people that are represented here today. We thank you. And I know it's denim day, so hopefully you have your denim on as well. So let us just get started. This is good news. I want everyone to know that. We want to just remind everybody of what MOVA represents and who we are. And so one of the things is that the MOVA's mission is to empower all victims and survivors of crime across the Commonwealth. And so MOVA's vision, we envision a Commonwealth in which all victims and survivors of crimes can access rights and high quality services that are reflective of our diverse communities, culturally responsive, and trauma informed, in which their voices and experiences are heard, valued, and amplified. So, the work that you are doing currently right now. And so we just want to point out a few things about MOVA's values this afternoon is that in all work that we do in our allyship and our stakeholders and our partners across Massachusetts, we want to make sure that we are survivor informed in our work. And so MOVA's work is driven by the voices of victims and survivors of crime and those that support them. And so we want to make sure that we're providing advocacy. And so MOVA will always advocate for enhanced rights, sort of what we're talking about today, and services for all victims and survivors of crime. And so one of the key things in what we do here at MOVA is that we believe in partnership. And we want to make sure that we collaborate and ally with agencies and individuals working to empower victims and survivors of crime. And so, in all those things that we do, we must make sure that there is equity when we're dealing with victims and survivors. And so, MOVA is committed to providing funding services and access for underserved and marginalized victims, survivors, and populations and communities all across the Commonwealth. And for those, I'm pretty sure everybody's fully aware of victim compensation, but just for a little reminder is that victim compensation is funded by state and federal funds that are primarily collected from criminal defendants. And so MOVA, and when we're issuing that, we follow state law and regulations in administering the funds. And so again, as a reminder, being fund of last result is that it's lawsuits, insurance money, or restitution are things that wouldn't be able to be rewarded with victim compensation. We would have to review that in order to be due to the impact of the crime when we're dealing with victim compensation. And so it lasts for the lifetime of the award. And so initially in the beginning, that claimant is able to have $25,000 for expenses to be compensated. And I'll talk really briefly about the type of expenses that can be compensated with victim compensation. Or for catastrophic crimes, homicide automatically goes there, and that's $50,000, or if somebody's severely hurt. And that means for the lifetime of that claim. And so they can apply for different expenses until that amount has been spent up. And so these are just some of the expenses that we do cover here at Victim Compensation. We do medical, ambulance bill to be exact. Sometimes people have co-pays, out-of-pocket expenses. Those are things where victims can be compensated for. Security measures, so like locks, ring cameras, those are things that we can also compensate for victims. Bedding and clothing. One of the things is once an advocate is assigned, they'll go over everything that can be compensated. They'll talk to them about the types of amounts, the caps on some of those things as well. Dental is something that can be compensated again with everything due to the impact of the crime. So mental health and therapy as well are some things that can be compensated, as well as lost wages. Oftentimes, when people are victims of violent crimes, sometimes they're out of work. Sometimes people can be out of work for 2 weeks, 6 months, and sometimes it can really be a lifetime journey of them trying to figure out how do they even get back to work. And so lost wages is something that we can compensate as well. Again, once someone meets that criteria for victim compensation. And crime scene cleanup is another thing that we wanted to name for expenses. For those that are viewing the webinar today who are familiar with victim compensation, dealing with homicide, which we know is a huge traumatic event for families, and we do a lot of compensation with homicide cases. And so under this particular area, which is dealt with a little differently with victim compensation, is we can help with funeral costs. We can deal with ancillaries, so that's like flowers, headstone, and plaques, burial costs, and loss of financial support for those that are surviving family member of that deceased victim. And so under that, we would have 14,000, 13,000 for funeral and 4,000 for ancillary costs. And so again, the advocate would help them through that process. And if you yourself are working with victims of violent crime and you ever need support and or questions, please feel free to reach out to us. We want to make sure that we miss no one across the state of Massachusetts. So with that being said, under the new regs, and I want people to, if anybody is nervous, I want you to alleviate all of that nerves today and just know we worked really hard. And I want to thank the team of MOVA, all the people last year who worked really hard to make sure that we can advocate at this level for victims. And so one of the things is that victim compensation functions under Mass General Laws, Chapter 258C, and Regulations 124 CMR 2. And so the laws versus the regulations is that we like to think of those as sort of a marriage. They go together hand in hand and they work together. And so the regulations are more detailed on how the law is being implemented. And MOVA was able to make changes, as we mentioned in the beginning, to those regulations, and they must align with the statute. And those officially went into effect last year, August 4th, 2025. And so one of the things that we like to think about when we made these shifts and we made these changes and to make sure that we are making access and things more available to victims of violent crimes. And so the first thing we want to make sure is that we are reducing any barriers that victims may face and or you yourself in the program that is helping to advocate for these victims. So the first thing is that we dealt with forensic exams. And so for many people that know, that's people going in to receive a rape kit and or dealing with a SANE exam for those that know it in that name. And so the hospitals now can directly bill to victim compensation through the emergency department. So that means even if the victim themselves does not file a separate claim for victim compensation, we are able to now directly bill. They can directly bill victim compensation and have those things done. And so the other thing I want to mention, even if the victim does not receive a forensic exam that day, whatever happened the day that they were at that hospital, so if they received x-rays, if there was testing, those are things that we can compensate under direct billing. Also victims, and this is really, really good news and a takeaway I hope for everyone this afternoon, is that they also will receive the full course of medical treatment versus in the past where victims would either get only a few days of the prophylactic medicine and then they would have to either pay out of pocket or pay through their private insurance. And so those now can be directly billed to victim compensation without that victim again having to apply for a claim. Now, if they wanted to file their own claim, that would not take away from that initial $25,000 award. So these are the things that we talk about when we say reducing barriers. And so again, so that's emergency department expense for a forensic exam. Again, even if they choose not to go forward with that exam as well. And then I mentioned about the medicine also. We just want to make sure that we are dealing with any barriers that may get in the way for those victims. Again, the payment will go directly to the hospital for that particular claim. So that would be a separate application here at victim compensation. Sexual assault treatments in emergency departments, again, are not applied to that direct amount. So we're excited when we talk about advocacy and access for victims. The other thing that I think is so important at victim compensation is that when I came on last year, we still had to get what is called an NOA. So it's notice of assent. And so that means in order for us at the time to compensate a claim, we would have to have that signed back by the victim. And so when we talk about alleviating stress from victims and having to reduce some of the trauma and re-traumatizing people, how can we make sure that we're accessing services and that we're advocating for them? And so this is a great, great thing that happened under the new regs. And so now they no longer have to sign an NOA. So it's not required. This helps expedite our process to payments and in order to make sure that we can compensate either directly to the claimant or the provider in that case. So prior to that change, the advocates could not move forward unless this was returned and signed. And this was for any pending payment. And so one of the things when we were talking about this is that this was burdensome, especially for homicide cases. And so now we're able to just move forward, make that payment request, and then that takes away sort of that pending process for victims and families. The other thing is we talk about reducing barriers. We also want to increase access, especially for service providers like yourself. And so how can we make sure that more victims are aware of the services and sort of their rights, dealing with the Victim Bill of Rights as well? And so we want to make sure that we're able to now look at what is called good cause for delay. We think about domestic violence survivors. There's lots of barriers. There can be difficulties for those survivors as well. And so one of the things is always going to be a requirement for us to have a report within 5 days of the date of crime. So we have to make sure that there's cooperation still with law enforcement. But now MOVA is now able to consider more broadly fear of safety for self and others. And again, a report is still a requirement under the statute. I think as myself who reviews these cases as an eligibility specialist here, I'm excited personally for this shift that helps support victims in the best way now. Also, for those who work with child abuse units that may be represented today, when we think about new regulations, we think about also child abuse claims and minors, and we do get a lot of those cases. And so just as a refresher for some, is that they have up until 18 if the parent is filing that victim compensation claim on behalf of that child. And also that parent can also receive sort of mental health and or therapy, and that's for the non-offending parent. The victim, once they turn 18, they have 3 years, so up until age 21, to file for that victim compensation claim. The other thing, so we talked about reducing barriers, we talked about providing more access across Commonwealth. We want to make sure also that we're expanding our services in victim compensation here at MOVA. So under this new regs, we're able to expand our med provider. So we've always been able to provide compensation for licensed providers, for an example, such as massage therapists and physical therapists who confirm that the treatment is needed as a direct result of the crime. The new regulations allows and permits us to consider compensation providers for services such as Reiki. Again, we want to support victims in their need of making sure that they're able to get the best help and support as they continue to process their trauma in the way that they need. So I think that's a huge barrier that we were able to lift for victims as we advocate on their behalf. The other process when we think about mental health services is teletherapy no longer. So this is something we had to do in the past. So now under this reg is that we no longer require face-to-face consultation or diagnosis. This is now up to the provider. So the advocate will still work in getting whatever verification for that claim for that victim. We've also have added transportation costs. As we think about the state of Massachusetts, sometimes people don't have access to transportation or they're not in places like Boston. So how can we make sure that victims are best supported, that they can get the treatment that they need? And so we're able to then compensate for mental health expenses. This was only allowed under medical services. So what is covered? So emergency or non-emergency services, such as dial a ride, taxi, or ride shares. This does not include public transportation, parking, or mileage. So we think about people who may live in rural areas, people who may not have access to ongoing transportation. Again, it's for those particular appointments. So lost wages, I mentioned a little bit earlier, but the shift in lost wages is MOVA has added that a victim or survivor who's been psychologically disabled due to the impact of the crime can now be eligible. Before, it was only someone that was medically disabled. And so the other piece around lost wages is that now we can deal with reduced time in working due to the impact of the crime now added, and also added overtime pay when there's a documented history for at least 3 months. So if a victim is applying for victim compensation, and one of the things that they're hoping to get compensated for is lost wages, we would just need to see a history of them going and working overtime prior to the date of crime. And that's part of the work that the advocates and the team does here at Victim Compensation. And so the examples that we want you to really sort of take away is that this has a huge impact on domestic violence and sexual assault violent crimes. Oftentimes when we think about medical disability, we want to also help those that are dealing with DV and survivors of that, because oftentimes they're dealing with things you can't see. They're dealing with disabilities that are mental. And so this really helps uplift their voice in this particular work. And so examples is both physical and psychological impacts may result in the victim having reduced capacity to work. And at the time of the crime, they have worked full time, and following the crime, they may only now be able to work partial, or sometimes some people may not even be able to return to work at all due to the impact of the crime. So we have really done a due diligence to support people there. Also, under the new regulations is something called loss of financial support. It's okay. Minor claimants, also homicide cases that were wholly or partially dependent on victim at the time of the crime can extend beyond age 18 or up to 21 with a court order. So that's things like financial support. Example from Emily is one of our amazing advocates who has done some work around the loss of financial support. And so in this case, this would be a homicide compensation may be available for an example. That's a huge one that we help with compensation there for loss of financial support from the victim and where the victim is a minor. The regulations previously said that compensation is available until the minor reaches the age of 18. So if there's a court order, in certain cases, we are able to compensate and review that application. So empowerment and privacy, huge. And when we talk about supporting survivors and their journey, we want to make sure not only that we're providing access, not only that we're lifting barriers, but that we're also empowering the voice and the needs of the survivors themselves. As we all know, survivors know what they need. They know what their experience, it's their trauma, it's their crime that they had to go through. And so how can we empower them to best support their own plan? Because as we know, every case of crime looks different in the state of Massachusetts. Even with domestic violence, every victim may have a different need. And so how can we again empower them? And so one of the things is that the treatment plan used to be required prior for our verification process. Well, we no longer require that because we want to ensure that we are protecting the victims and survivors in their confidentiality. We do still require that the treatment being provided is needed due to the direct result of the crime. So again, this is work that the advocate is going to do. They're going to find out who their clinician and/or therapist is and get the necessary forms to make sure that they can compensate that victim. So we talk about compensation that can go directly to the provider, or if the victim themselves had an out-of-pocket expense, they can be directly compensated as well. The other thing, which could be sometimes a hot topic for people, but oftentimes it's during the homicide cases here. And so we think about crowdfunding. And so under the new regulations, if a family gets money through third party like a GoFundMe and or a church or a community, we do not want to penalize people in that. And so that's not going to hinder their victim compensation application or take away from the funds that they could be compensated for the funeral and or burial expenses. So they're not required to report that amount to victim compensation. So we just want to be clear about that. And again, that's to empower and support the victims and surviving family members of that deceased loved one. I'm going to turn over this piece now to my wonderful, amazing director, Patty McNamara.
Thank you, Nikita. That was amazing. I'm so grateful to have you as part of our team here. So one final change that we want to highlight is that victim compensation records are now legally confidential and privileged. I'm going to explain what that means and how it impacts our collaboration. So confidentiality is a legal obligation imposed on MOVA to protect the information that we hold regarding a victim compensation claim. Many of you who work in community programs also work under confidentiality. So it means that we cannot share any information about a claim without the permission of the claimant. When we receive a request for compensation for certain types of expenses, some of which Nikita was talking about, mental health treatment or medical treatment, the regulations require that we request information to verify that the treatment is crime-related. So we obtain a release from the claimant that permits us to make these requests. We have revised our forms, we call them verification forms, to limit how much information we're requesting from providers so that we get only the information that we need. And as Nikita said, we no longer have to ask for treatment plans for mental health counseling. We include in the verification forms also for the providers that we want them to give us only the information that we're asking for and not send any additional information. We inform the claimants when we're working with them of what documentation we need and why we need it. We make every effort to be transparent with them. Our goal is to maximize both their access to victim compensation and the protections of their privacy. Privilege is a legal right that belongs to the claimant that allows them to protect access to their confidential records in a court case. So what that means is that a litigant or a court cannot access confidential records without the consent of the survivor. Many of you in community and legal systems programs are probably familiar with the concept of privilege. Domestic and sexual violence counselors' records, for example, are also protected as confidential and privileged. In order to protect the privilege, we're very careful about who we speak to while we're processing a claim, what information we request and provide. The more people we speak to, the more information we hold, the less protection there is for the claimant. Those of you involved with criminal cases may have had experience with defense counsel seeking access to confidential records. So in a criminal case, there is an exception to the survivor being able to always be able to protect their records. There's a process where a court may order access to confidential records. This requires the defense to meet certain legal requirements and the court to make very specific findings. But knowing that this is possible is another reason why we're very careful and thoughtful about the information that we collect and hold in victim compensation. One thing that's very important to protecting the victim or survivor's privilege is that the records, the confidentiality is protected, that it's maintained. The legal right of the privilege depends on the records being confidential. So we can go to the next slide. This is an important new protection of victim compensation records, and it's for the purpose of supporting victims and survivors in accessing their right to compensation without risking exposure of their private, confidential information. It goes hand in hand with some of the changes in the regulations that we've spoken about. We still want to partner with advocates, and we want to do so with the involvement and consent of the claimant. We don't want this to be a barrier to supporting survivors and claimants. We want to support both their privacy and their access to victim compensation. So how does this impact our collaboration? We won't ask advocates in the legal system for some information that was requested in the past. For example, we won't ask you for information about the victim's cooperation or whether they engaged in what's called contributory conduct. We're going to gather that information separately through the police reports. We may still ask victim witness advocates for assistance in obtaining a police report if we've been unable to access it directly, or if a police report is not available, help in getting information about a criminal complaint or an indictment. We need this information under our statute and regulations to confirm that a report has been made so that we can open a claim. If you reach out to us from any kind of a program, we will ask if you have permission from the claimant to speak with us. And if not, we'll contact the claimant and get that permission so that we can engage in conversation with you at their request. If you reach out to us, we may also offer that we can follow up directly with the claimant. It's very, very helpful when you reach out and let us know that the claimant has certain concerns or needs so that we can respond to them. We can always provide information to you in general about victim compensation eligibility and access, our process and our timelines. So if we don't have specific permission from the victim or survivor, we can walk you through what to expect, how things will proceed within victim compensation in the hopes that that information can be helpful. And we can always receive information from you. So we're definitely, it's a shift in the way that we communicate and the kinds of information that we can share and the information that we protect, but we're very committed to doing this in a way that's going to support survivors and claimants in moving the process on. All right, so we're going to move now to open up for questions. Thank you all for listening to the presentation. Those were wonderful questions, and please feel free to reach out to us directly also if you need more clarification or more information or support for survivors. Nikki is going to talk a little bit about how to get in touch with us.
So thank you so much, Patty, for explaining everything and going through the questions. First of all, I just want to give you all a round of applause for the work that you do. We want to thank you as well as we think about allyship and connecting and equity, really making sure that we, again, are breaking down barriers for victims and survivors across the Commonwealth. And so we want you to be reminded is that applications can be filled online and you could submit those via email. And on your screen, you will see an email that says VCC correspondence at mass.gov. And so that's where you can email applications directly to victim compensation, or you can send them by mail and or hand them in person here at our Boston office. There's some numbers on your screen to reach us as well. And again, if you have questions or if you want to know about the process of victim compensation or some difficulty or some situations you're running to, or you're not sure, always feel free to reach out to me directly here at MOVA. That's part of my role. If you are interested in training or opportunities for us to come to you, I will travel to your agency or your police department and talk about victim compensation. Bring one of the advocates with me as well. We want to make sure to network. We want to make sure, again, that victims across the Commonwealth are having access to victim compensation. If you're not sure if a victim should apply, again, have them apply. And part of our role here is to make sure how can we best support them if they meet criteria or not. So we thank you again during this month of victims' rights. We thank you for, again, your work that you do to continue to advocate and rally for victims and survivors of all the various violent crimes that we have to all see here in the state of Massachusetts. So again, for victim compensation here at MOVA, we appreciate you. We thank you for attending this webinar this afternoon. And I look forward to hearing from some of you. I can be reached by phone and email as well. Thank you again.
Thank you, Nikita and Patty, for walking us through these exciting updates today. We encourage everyone to stay engaged for future updates and opportunities to continue this important conversation. Thank you also to the ASL and CART interpreters for supporting accessibility today. And thanks again for all that you do. This has been a meaningful Victim Rights Month. Thanks to all of you for everything you're doing to support survivors across the Commonwealth and on behalf of MOVA. Thanks for joining us today for this meaningful session.